Are you logged in as published writer?
Oh, yes.
That
Let me
might,
go. Okay, let me go.
that's fine. I'll let you in now. We don't allow observations in Zoom. They have to go to YouTube. So let me let you in, okay? Okay. And then do you have a camera?
I do.
There. Okay. All right, perfect. So I know when we were here last, I had given Ms. Quinata some additional time. I know you had asked to speak with counsel. I haven't seen anything, so why don't I start with you on your ability to obtain counsel for today?
Sure. I decided, I already did everything that I needed to do.
Okay.
Sorry, can you hear me?
Yes, I can.
Okay. So I decided that I already filed everything that needed to be filed. I don't know. I can't remember first of all, I want to apologize because I wasn't feeling very well last time I was in court.
You are fine.
That's the first thing I want to say.
You are fine. You sound like you still might be a little bit sick, so.
A little bit, but I'm getting better. That's all that matters. I'm getting my voice back.
Good.
But I wanted to say that I already filed everything that I was supposed to, but I can't remember if I filed a roommate release. Matthew Posner actually moved out last year, and I took full responsibility of everything. So I did want to say that on record. Okay. And then I also filed a quick deed claim, and that's actually in Cowlitz County Auditor's Office already. And Elazar signed that. And he also did a warranty deed. And so I'm not exactly sure.
What was the date that was filed with the auditor?
I have getting older. Let me put these fancy web boys on. 4/29. And the reason being is because I didn't have the money to file the paperwork. Okay. I am a single mom, and it's just Marley and I.
Did Ms. Radecki, did you receive that?
So, Your Honor, I received some deed from her. I don't recall if that was the date. I can check my inbox, though. But there was nothing to do with her name, to the best of my recollection on it, nor Mr. Jackson's interest conveyed to Ms. Kanata.
Okay. So it sounds like we're ready to move forward then. So Ms. Radecki, this is your motion, so I'll turn it over to you. And then Ms. Quinata, you will have the option and ability to respond.
Sure.
Okay, go ahead, Ms. Radecki.
Thank you, Your Honors. Plaintiff is Annette Jackson. We're seeking a preliminary injunction and a writ of ejectment today so that my client can get her home back. In Washington, courts that assess a three-part test generally when trying to assess whether a preliminary injunction is appropriate. Those three prongs does the person have clear right to possession? Is there a well-grounded fear or invasion of that right? And then the third one is there continued injury resulting from defendant's unlawful occupancy? So ultimately, the relief that we are requesting today is immediate removal of defendants and any unauthorized occupants, in order prohibiting the defendants from taking, damaging, moving, or selling any of plaintiff's property, restoration of any personal property that's already been taken or damaged, and then authorization for law enforcement to enforce the ejectment order.
A straightforward motion for ejectment typically arises when someone remains on a property without any legal right to be there. Before going further, it is helpful to clarify the difference between eviction and ejectment, as the terms are often confused. While both involve removing someone from property, the key distinction lies in the occupant's legal status. Eviction applies when the person has a legitimate legal right to occupy the premises, such as a tenant under a lease agreement, yet must be lawfully removed due to breach of terms or expiration of tenancy. Ejectment, on the other hand, is used when the individual never had a legal right to possess the property, such as a hotel guest refusing to vacate a room after their stay ends, or a former partner who refuses to leave property that legally belongs to someone else following a separation or divorce. Understanding this distinction ensures the correct legal remedy is pursued and helps avoid unnecessary procedural delays.
So beginning on plaintiff's clear right to possession, plaintiff is the clear sole legal owner of the premises pursuant to a final divorce decree entered on August 26, 2024 in Cowlitz County. The cause number was 232-002-44008. That was attached as Exhibit D to our complaint. Defendants have never had a valid lease agreement, never had paid rent or a legal right to reside on the premises. The defendants had submitted a lease agreement. They purported it was valid, but it was not issued by Ms. Jackson, the plaintiff. It was not signed by her. Ultimately, they are not tenants. The defendants entered the premises without plaintiff's knowledge or consent after she was forced to leave the home due to domestic violence. RCW 7.28 supports plaintiff's legal right to possession as the record and sole title holder and the only legal owner to the property. Defendants don't assert any valid ownership rights or tenancy. They were at best holdover licensees, but now have been trespassers since they were served with the proper notice to vacate back in February of 2025. So moving on to the next factor, the well-founded fear of immediate invasion of the rights. Defendants remain in unlawful possession and continue inviting strangers onto the property. Law enforcement frequently visits the property. Plaintiff had visited the home in December of 2024 with law enforcement and discovered a number of concerning things, but especially highlighting missing personal property. Her dogs were locked inside the house without food or water, and there was just general disrepair and suspicious activity occurring inside the home. The continued occupation of the defendants prevents plaintiff from accessing, maintaining, or safeguarding her property, and has violated her rights as a property owner. So moving on to the third and final factor regarding the actual and substantial injury to the plaintiff. There has been ongoing economic and personal harm that the plaintiff, Ms. Jackson, has suffered from the inability to reside in her home. She's had to incur additional financial expenses to house herself elsewhere in the interim. Property has been missing and gone damaged inside her home, the property that's subject of the action. She does have concerns about the well-being and welfare of her animals and other personal property that she's not been able to observe in the past 6 months. And this has caused her a great deal of emotional distress, and she has safety concerns about the property and welfare of everything there. Defendant's presence is causing continued deterioration and damages, and plaintiff is concerned about further damages if the preliminary injunction is not granted today. At this point, these injuries, a lot of them are irreparable and not compensable solely with monetary damages. So regarding the balance of equities, just to touch on that for the courts may weigh hardship when considering a preliminary injunction, but only for innocent parties generally. The defendants were warned of their status as trespassers and received a 3-day notice to quit on or about February 8th of 2025, but failed to vacate and clearly still occupied the premises. They knowingly remain without rights to do so, and Ms. Jackson is entitled to recover her property back and eject the defendant immediately without further delay. Plaintiff's hardship, loss of access to the property, damage to personal possessions, possibly her animals, and an inability to exercise ownership rights far outweighs any minimal inconvenience to the defendants at this point. They've had well over 3 months of notice to vacate and have still failed to do so or show any indication that that's their intention. At this point, we believe that the injunctive relief is appropriate as plaintiff has clearly satisfied all 3 factors: the clear legal right to possession as the sole owner, that she does have a well-grounded fear and immediate invasion of that right. There's continued injury resulting from defendant's unlawful occupancy of the premises. And courts may act to preserve the status quo and to prevent loss or damage during litigation. So we're requesting the courts to grant this preliminary injunction, to grant the order ejecting the defendants from further damage. And I did want to touch too on the bond requirement for Court Rule 65B. So it does require a bond unless it's waived. We would just simply request that the court waive the bond, but if the court is inclined to issue one, that it would be a minimal bond of just $100 due to the 2 main factors of there's a lack of lawful claim or tenancy of ownership or ownership by the defendants. There's no credible risk of this being a wrongful action at this point. And also we would reiterate a request for fees and costs associated with this action. So to sum up, we are just requesting that the court grant the order for the preliminary injunction, ejecting the defendants from the property immediately and enjoining them from interfering further with plaintiff's property or damaging it, and to authorize law enforcement to remove them immediately.
As mentioned earlier, the situation itself is fairly straightforward. What follows, however, is a revealing attempt to justify conduct that appears to cross into potential real estate fraud. Rather than relying on interpretation alone, we can examine the explanation in her own words, an account that raises significant questions about both intent and legality.
Okay, so Ms. Quinata, go ahead. I did review your response, and I did review kind of the preliminary argument that you have, or kind of the main argument, I should say, regarding adverse possession. I know that you're not doing this without an attorney, but typically adverse possession does require quite a lengthy period of open, notorious, hostile use. So if you want to start there, feel free. Go ahead.
Okay. First thing I want to say with the adverse possession, I've had to fix the furnace. I've had to fix everything on the maintenance side of that. I already mentioned that Matthew's not there. It's just me and my son. And I kind of took some notes a little bit, but I've been there for almost 3 years, going on 3 years. I don't know how long she's lived there. When Eleazar left, and I'm not part of their divorce case, so whatever property she had went with Eleazar, and whatever property she had went with her. So I don't have any of her property. The other thing is, ADT will verify that they never came and served me. And so I actually put up ADT systems because there were people that were coming to the house, and it was just Marley and I. And so I do have that. And then I also have that I was reaching out to her, and I posted notices, hey, what's going on? And that's verifiable through Woodland Police Department, because they had taken some reports and had said, we've seen a notice on the door, and they actually verified that there wasn't public notice on the door and on the street side, so that she could see, hey, this is what I'm doing. Where do I pay my rent? What do I do? So I started that, I think, in September, whenever their divorce was. I started reaching out to her, and all I got was, I talked to, I always forget his name, the mayor of Woodland. Anyways, I was talking with him, and I said, is there a reason why all this is going on? And he said, well, she still owns the house. I go, I know, but I'm just trying to communicate with him. So he knows about the situation too. And then I also spoke with my son's advocate through missing and exploited children. I've been talking with her about it, because Annette had installed cameras at the house, and that's why we ended up getting ADT. So I do have everything that is verifiable through Woodland Police Department, the mayor of Woodland, and through ADT, that I was never been served. I've never even received a notice saying, hey, new ownership. I've never received any of that. The only thing I received was an ejection. I was like, what is an ejection? I've never heard of it. So I do a little bit of research, and I understand what it is, but I'm not a squatter. I'm actually on a lease. I signed it with Eleazar. And I'm kind of glad I did, because that's how it started, was, that we were roommates, and then it went into this whole big thing, and I've been dragged into their divorce for no reason. I mean, I get and I understand, but I'm not part of that case. The case, like today, is just about the house. I'm on a lease. There was an adverse possession because I kept trying to reach out to her and put posting notices, and I didn't know how to contact her. Then after that, what else was going on? Basically, that's pretty much it. I mean, and then I said, and then that's right. I got a foreclosure notice on the door, and I was like, oh my gosh, what's going on? And so then I actually submitted the information to the mortgage company saying, hey, I'm right here. What can we do? And I filed and submitted a 1099A with them. And then that's when I asked Eleazar. He said he didn't want anything to do with that house. I said, okay, well, will you sign? I didn't know what kind of deed to sign from him because I couldn't get a hold of Annette. And so then Elazar had signed all of them pretty much because I put them together. I was like, I don't know, this is what the auditor's office is asking me for, but I did pay on the mortgage and the taxes. I did the last 2 years of taxes. I paid those off. And then I also did the mortgage. I have an agreement with the mortgage company. So she was already at default before I even made this decision or even decided to go into this position. So that's where I panicked, and that's where I started asking around and doing a little bit of research. And so that's where I'm at.
You're paying the mortgage every month?
No, I paid it off with my trust fund.
A quick but important question. When you claim the property was paid off using your trust fund, are you referring to a legitimate, legally established trust, supported by proper documentation and verifiable financial records, or one of those so-called trust me, it's real arrangements that exist only as a claim without proof? Because if it falls into the latter category, it holds no legal credibility. In matters of property ownership and financial responsibility, assertions alone carry no weight. Only properly structured, legally recognized instruments count. Simply put, if the trust fund cannot be substantiated through valid records, then it does not qualify as a genuine source of payment, and the claim itself becomes unreliable.
When was that?
I submitted it with the paperwork that I gave you guys. It is, hold on. Let's see. And actually it was more than what they, hold on it. Working in this little tiny spot. So hang on. It was paid on, of course I got a really bad copy. I'm gonna have to pull up the original document because this is really light, the one that I submitted. But if you don't mind waiting for just a moment, I can just grab my bag and pull it out. If you'd like me to grab that and tell you the date that I paid it.
Yeah, that would be helpful.
Okay, hang on just a moment. I dropped my box right before we started this, and it was with my paperwork, but the copy that I have, the hard copy, I just can't read the copy that I made you guys.
There's a 1099 that's a poor
it's
quality.
12/24/24. Sorry, I just got it.
December of 2024.
Yes.
And did you pay the $20,000 amount, or how much?
No,
did you
I paid 487. Wait, 400. Can't even read it. $418.79. I have $79.42. And then I also paid the taxes on it, and I can grab that.
So tell me the mortgage amount that you paid in total.
$418.70. Oh no, $418,079.
Okay.
Yeah.
Okay. And Ms. Radecki, your client does she agree with the fact that the mortgage was paid off?
No.
No, she does not. Okay.
That is news to me.
And I don't have proof of that in the file, Ms. Quinata. Do you have a document there that shows?
It was on the 1099 because I had to file this with the IRS, and it's submitted as an attachment.
It's
attachment H.
I understand. So what I was telling you is you did submit a 1099 to us, but it's of such poor quality that none of the numbers are readable.
Okay.
It appears to be in handwriting. So the title of it says acquisition or abandonment of secured property. Right. That's not a receipt from the mortgage company that tells me that they've received payments.
I have a V and a B and a D, 10 and 8, all of those. Which actually so I've been talking with Freedom Mortgage, and somebody had submitted that some other mortgage had the deed, so I confirmed with Freedom Mortgage, and they were like, no, we still own the loan and we still own the deed.
Exactly. The mortgage company still retains its legal interest in both the loan and the deed, regardless of any attempted use of a 1099 form to claim otherwise. filing documents does not by itself transfer ownership or extinguish a valid mortgage obligation. Without proper legal satisfaction of the debt, the lender's rights remain firmly in place, and any attempt to bypass that process raises serious legal concerns. With that established, let's now turn to what the judge has to say on the matter, as the court's interpretation ultimately determines how these claims stand under the law.
I guess what's troubling to me is that you clearly were aware that in September of 2024, in a final divorce decree, unlike what Mr. Jackson submitted to the mortgage company and clearly just a couple weeks ago to Cowlitz County, the divorce decree did not just state that Ms. Jackson was responsible for the payments. It stated that she was given the property.
Yeah.
And I'm not. Well, hold on. So she was given possession of the property, and he was mandated to leave the property. And so first and foremost, I mean, I have some concerns about what's happening behind the scenes with Mr. Jackson towards this property that he is telling state, county agencies that he has the right to this property. He does not. And you now have received through this lawsuit proof of that. You have not been in the property long enough to obtain it by adverse possession. Even if you had met all the other factors, you're not even close, frankly, timeline wise.
Right.
So there's no question in my mind that a preliminary injunction is necessary in this case. The only question for me is if a mortgage in the amount of $418,000 was paid,
right,
then I would be requiring a bond of more significance. And so I guess let me hear from Ms. Radecki first, but we need to figure out if there's been $418,000 paid towards the house. Ms. Radecki, I know you've already said kind of this is news to you. What do you want me to know?
So, Your Honor, it's interesting because Ms. Kanata claims to be a tenant, yet she's also simultaneously alleging that she's paying off $400,000 to a house that she very much admits is not hers. So that information, the inconsistencies between that in itself is troubling to me. And I think that her having submitted documents and pleadings to her for both of her claims to the court is also concerning. Like I said, that doesn't make logical sense. We have no proof other than her words today that she paid off this mortgage. And again, so I would just request that the court not take that into consideration, or at the very minimum, I guess, require a $100 bond rather than waiving it, because again, we just have nothing further to substantiate the fact that she apparently gratuitously made a payment of over $400,000 to a house that she knows is not hers and is not going to be hers. It was officially granted to Ms. Jackson.
So Ms. Quinata, I don't want you to get the mortgage company online. That wouldn't be admissible here right now anyway, so don't do that. Here's what I'm going to do. I do think, again, I'm going to grant the preliminary injunction. I'm going to set this just 1 week before I sign that order, though. Ms. Quinata, I'm going to give you a couple days to file with Ms. Radecki by Friday proof that you've paid off the mortgage on the house. You personally have paid off the mortgage on the house. I want you to file that with Ms. Radecki in the court. And if we get that, and I agree that you've paid it off, I'll set the appropriate bond. But I am going to sign a preliminary injunction. I find that all three factors are met. There is no viable defense to ownership of this property. And I'll tell you again, I'm very concerned that there are acts of dishonesty, to put it lightly, that have happened in the last couple of weeks with the documents that Mr. Jackson and you have filed with Cowlitz County. And I'll tell you specifically what I'm referring to.
Sure.
You're here in court telling me that you paid $418,000 to the court.
No, to the mortgage company.
Or to the mortgage company, thank you. I misspoke. But in the documents that you filed with the court on the quit claim deed, you stated that the property was gifted to you and you paid nothing for it. And so no excise.
I didn't know what to
hold
do.
on. So no excise tax. So if you bought the house for $418,000, the things that you're saying to Cowlitz County and to this court are inconsistent and probably, I would say, fraudulent.
That the reason why I said at the very beginning that I had him sign all of them. Do you remember? I said, sorry about that. I said I had him sign all of the deeds. I had a warranty deed, a gifted. I had him sign all of them because I wasn't sure.
But you had him do that after you already knew that he has no ownership rights to that.
I did not know that. I'm not part of their divorce case.
But the complaint that you were served with has that document in it.
What date, what complaint, which one? Because I have verification that they never served me through ADT.
The one that Ms. Radecki's office filed for this case has the divorce decree.
Are you talking? Okay. That's correct.
Okay.
So that just came to me. I'm still on a lease. That's the bottom line. I was on a lease. Before all of this happened, I was on a lease.
I am disagreeing with your facts that are presented to the court. So again, I'm not kicking you out today, but next week I am going to sign it next Wednesday at 2. Are you both available to reappear on this docket?
Let me confirm.
Okay.
I am, Your Honor.
Okay.
All right, it appears she now has 1 week to put everything in order and demonstrate that the proper documentation was actually filed and that the mortgage was legitimately satisfied through her own financial means. This time frame provides an opportunity to present verifiable evidence, official records, valid filings, and proof of payment that can withstand scrutiny. Ultimately, claims alone are not sufficient. Only properly executed paperwork and confirmed financial transactions will establish whether the obligation was truly fulfilled.
So I have unsuccessfully sent that to her, but in essence, it's just the mortgage statement that Ms. Jackson got from Freedom Mortgage stating that the balance was not paid off, in fact.
Okay.
And I'm not sure if the court would like to call this in a little bit. I can email that to her right now. It's a pretty brief document, just so she has the opportunity to.
Let's do that. So I'm going to recall this case. I'll have Ms. Radecki email that document to you because it does have a mortgage statement with a current date. Looks like it claims to be from May 19, 2025, which would purport to show that it is not paid off. And that really is, as you know from our prior hearing, I'm not going to relitigate today my decision on the writ of ejectment. What I'm here to decide today only is the amount of bond, if any, that Ms. Jackson would need to post. And as you will recall, in order for me to make that decision, I wanted to know if Ms. Quinata had paid significant sums of money towards that home, in which case I would be more likely to set a bond than if not. So that's what we're going to decide today, Ms. Quinata. I know some of your filings reference some other issues, but solely in front of me today is what have you paid towards the house?
99A, which I have communication with Freedom Mortgage. And so I have that email, but I wasn't able to submit it because I just got it back. And they said that they wouldn't be able to send me a receipt of received until around the 6th of June.
So you've had a chance to review Ms. Jackson's declaration?
I have.
Okay. So I guess Ms. Radecki, I'll have you go first regarding any non-request for bond based on the facts that I asked for some more information on, and then I'll go to Ms. Quinata.
Okay. So, Your Honor, we are requesting no bond in conjunction with the writ for ejectment for the preliminary injunction. Reason being, Ms. Quinata last week indicated to the court that she paid off the balance of the mortgage in excess of $400,000. She indicated that she did this action sometime in the end of April 2025. My client, Annette Jackson, who's the owner of the property located at 124, she contacted Freedom Mortgage, who is the lender for the home, after the court hearing, and got a current balance as of May 19th, 2025. We have included that in her declaration, and she represents that that is an accurate depiction of the mortgage statement. The only change is that the loan number has been redacted, but otherwise it is a true copy of what Freedom Mortgage has given her. It indicates that there is an active balance of over $400,000 still, and this is information given straight from the lender, which obviously starkly contrasts what Ms. Kanata is telling the court last week and this week. So we would just request that the court take that into consideration, the fact that she has not paid off any balance. There's no proof to that, and in fact, the proof is to the contrary, the fact that there's still the full outstanding balance. There's a current amount due of $27,872.61. So we would just request that the court take that into consideration and not issue a bond for this matter, given that information.
Ms. Quinata, what would you like the court to know?
Well, just like Ms. Radetti said, the account number has changed. And the reason being the account number's changed is because it's mine now. I paid that off. It wasn't my fault that they lost the 1099-A to give me a receipt. So that's kind of what had happened. I had mailed it in. I mailed everything in together. They lost the 1099. After court that day, I called them and I asked them. They said they lost that portion of it, so they can't give me a receipt until they receive it. So I sent it to them. But if you notice, just like she said, they changed the account number because it's no longer under Miss Jackson. It's under my name.
That claim simply doesn't hold up. Are you seriously suggesting that the mortgage company is contesting your position in court because they somehow misplaced your 1099 form, and that the only reason you cannot produce a receipt is because it won't be available until early June? Or is the more realistic explanation that a 1099 form is not, and has never been, a valid method for satisfying a mortgage obligation, and the lender is not obligated to transfer ownership of a property without proper payment? Regardless of the reasoning presented, it appears the judge is now prepared to address the argument directly and clarify the legal standing of these claims once and for all.